days. And joining us now to talk more is criminal defense attorney and host of Courtroom Confidential, Joshua Ritter. Good morning, Joshua. Great to see you today.
Oh, thank you so much. Good to see you.
So a lot has been made of this. The newly elected Los Angeles District Attorney, Nathan Hochman, he's tried getting the hearing withdrawn, saying the brothers have not taken full accountability in the deaths of their parents. Do you expect that the prosecution is going to be making attempts to delay today's hearing?
I don't think so. Even though we've had several delays, it looks like we've finally put aside all the kind of preliminary issues. And today actually might be the day that we start the hearing on the substantive question of whether or not the brothers will be resentenced. So it's expected to go a couple of days. I will say that the defense has said that initially they were going to call maybe a couple dozen witnesses. Now they've cut that nearly in half or more. And we do expect that over the course of today, most of today, perhaps even bleeding into tomorrow, that we will finally have this presented to a judge for a decision.
Oh, the whole thing is just sickening. You've seen the documentaries and everything on streaming as well. But talk to me about this youthful offender law and them being under the age of 26. It's not like they were 14 or 11 or something. Tell me about that law.
No, it is unique to California. There was a change in the legislature. It had nothing to do with this case, but there was a decision made that those who were under the age of 26 at the time that they committed the crimes should be able to have their sentences not reduced, but the ability to enjoy perhaps parole at a time that they wouldn't otherwise had they committed the offense later in age. And so, yes, even though it would still be a double homicide, they would still have been sentenced to 50 years to life for these crimes. Because of their age at the time that the crimes were committed, they would become immediately eligible for parole if the special circumstances in this case are stricken. And that's essentially what's being asked to be done, is have the special circumstance, which made them eligible for the death penalty, by the way, stricken, which would make them immediately eligible for parole.
And so what kind of testimony do you expect the judge to hear today then?
I think it's going to be a lot of things like perhaps people inside the Department of Corrections talking about how they've behaved. It's going to be family members. It's going to concentrate, at least from the defense, a lot on their behavior since the time of the crimes. And they're going to try to keep it focused there, where I imagine the DA's office, and we've already seen this in prior presentations, is going to try to bring the attention back to the brutality of the crimes themselves. And the judge is going to have to weigh all of that.
Right, and the defense attorney, Mark Garagos, actually wanted Hochman to be recused from the case, but he withdrew his request on Friday. Why was that?
I think strategy-wise, I think that Garagos realized that he's not getting any cooperation or any love from the DA's office and the AG's office, who this would have landed on their desk had the judge allowed for a recusal of the DA's office, was probably no more friendly toward their cause. So they decided, let's just go with what we've got. The judge, I will say, has been very objective and reasonable. And so they probably think, listen, it's up to the judge anyways. Let's just make our arguments and see what we can get done here.
Okay. And the judge did say that he would allow some of the parole board's risk assessment to be used in the resentencing hearing, which said Erik and Lyle pose a moderate risk to the community if they were indeed released. So how will their attorneys argue against this?
Yeah, that was a little bit of a surprising move. I think because they had prior risk assessments done and they had all been low, and I think they had expected that this one would be the same. With it coming back moderate, again, that doesn't sound all that horrible, but it's certainly not what they would have hoped for in it being a low risk assessment. I think they're going to argue that the judge can, not disregard it, but not allow it to change his decision, that it doesn't change anything about who they are as people since they've been in prison. And the things that are pointed to in that report as causing them to have a moderate risk are things like, perhaps trafficking of drugs, other kind of misconduct, but nothing that shows any propensity towards violence.
Right, and just society as a whole views sexual abuse completely different than they did back in the 90s, and of course the allegations that their father was sexually abusive toward them. Josh Ritter, thank you so much for your time today. Appreciate it.
Thank you for having me.